Chalo. Welcome to Sanjivani once again. Now, so in today's class, what we are going to start? Today we are going to first start with debt instruments. Okay. And in debt instruments, first we are going to do what? Deposits. Okay. As debenture part is comparatively easy, we will first do deposits from this entire chapter from my notes and your ICSI module, and then we will start with the new chapter. Okay, so let's start. Now you can see here, yes, the debt instruments. Yes, so in debt instruments there are two parts, right? Part A, part B. Part A talks about what? Debentures. Part B talks about deposits. Okay. Yes, surely I'll share the notes. Don't worry. Now concentrate, please. So part B is deposits. So we are today covering deposits. Now when we talk about deposits, so we have to go from section 73 to 76 as well as companies acceptance of deposit rules 2014. Okay, now what are deposits? So if we start with the definition, so deposits are defined in section 2 clause 31. Okay, so what are deposits? So deposit says that any receipt of fund by the company is considered as deposit excluding as prescribed in rule 2 of companies acceptance of deposit rules 2014. Okay, what is this? Any receipt of fund by the company is considered as deposits. Means, see, suppose here the definition says that any receipt of fund. Now tell me, company receive funds for various reasons. So the definition says that any receipt of fund is treated as deposit. Any type of receipt of fund is treated as deposit, but excluding the following. So there is a list given in rule 2 of companies acceptance of deposit rules 2014. Yes. So yes, excluding the list. So what is the list? So now we are going to start with the list. So in this list, in your ICSI module, this list is divided into like 18 parts. Okay, I have covered that in 22 points. Oh, okay, so the list what we are starting now is what? All this is the excluding the following. Okay, so whatever we are going to do now, these are not deposits. Other than these, any receipt of fund is treated as deposit. Okay, so let's start with the first one. So see, the first one is if company, see the first point, if company receive funds from central government, state government or local authority. So yes, so company is receiving funds. So is this receipt of fund? Yes, this is receipt of fund for the company. So is this receipt of fund a deposit? Answer is no. This is not a deposit. Okay, because we are doing the list which is given in the excluding the following, that is given in rule number 2. So if company is receiving any funds, any amount from any of these governments or local authority, it is not treated as deposit. So what is deposit? Deposit is any receipt of fund is treated as deposit excluding the following. So what is the second point? Second point says that if company receives loan, financial assistance from any of the following. Which of the following? Multilateral financial institution, insurance companies, public financial institutions, scheduled bank, commercial papers, money market instruments, person residing outside India, foreign government, foreign banks, and so on. So if company receive funds from any of the following, is this receipt of fund? Yes, this is receipt of fund, but this is not a deposit. Okay, because again this is given in rule number 2. So what is deposit? Any receipt of fund excluding the following, but this is not a deposit. Okay, yes. Next is if company receives fund from another company. Come on, one company is receiving some funds from another company. So is this receipt of fund for the company? Yes, this is receipt of fund, but is this a deposit? No, this is intercorporate loan, When one company receives money from another company, it is intercorporate loan. Therefore, it is not a deposit. Okay. Now see, are you getting the point now? If suppose if company receives a fund, if company receives any amount which is other than this, then that is considered as deposit. So if suppose company is having receipt of fund, and if that receipt of fund is not part of this list, so that receipt of fund is deposit. So now what to do next? Next is nothing but you need to apply regulatory framework of this deposits. What is regulatory framework? That is, you need to consider this amount, you need to treat this money under section 73 to 76, okay, and company acceptance of deposit rules. So those sections shall be applicable on this receipt of funds. Okay, clear? Everyone done? Okay, so this receipt of fund. So this receipt of fund is not a deposit. What is next? Next is, if company receives share application money from investors. You know, people who want to subscribe shares, they will first pay what? They will pay share application money. So again, company is receiving some money. So again, this is what? Receipt of fund in the form of share application money. So tell me, is this receipt of fund a deposit? No, this is not a deposit. This is share application money. So this is not a deposit, but there are rules for this. You know what? When company receives share application money, it is, why company has received the money? For allotting shares. So company have to now allot the shares. So company has received share application money. That receipt of fund is not a deposit. Firstly, are you getting it? Why each and every point, why these clarifications are given here? Why? Because the definition says any receipt of fund. So if suppose if any of the thing is not given in this list, then it will automatically become a deposit. Then 73 to 76 section shall be applicable on that money. Correct? So therefore, yes. So if company is receiving share application money, so what shall company do? Firstly, that receipt of fund is not a deposit. Secondly, what company shall do now? Company have to make the allotment of shares within a period of 60 days. Company have to make the allotment of shares within 60 days. If company does not allot shares within 60 days, then what company shall do? Company have to refund the share application money in next 15 days. That is the rule. So make the allotment in 60 days. If company is not making allotment, refund share application money in next 15 days. Correct? But if company does not refund the share application money in 15 days, then come on, is that amount with the company? Yes. So such receipt of fund with the company shall be treated as deposits. Then it shall be treated as deposits. Easy, everyone? Come on, one more time this point, we will do this. So company has received a share application money, okay, from the investors, that is proposed investors. Now that is receipt of fund for the company. So is that receipt of fund deposit? Answer is no, it is not a deposit. Okay, but there are rules for this. If company has received share application money, company have to make the allotment of shares within 60 days. If company has not made the allotment in 60 days, company have to refund the share application money to the investors within next 15 days. If company does not make the refund in next 15 days, then that amount what company is having share application money, that amount shall be treated as deposits. Easy? Fine. What is next? Now point number 5. See, if company, see the first point, if company is receiving funds from its directors. Okay. So if company is receiving fund from its directors, is that receipt of fund for the company? Yes, that is receipt of fund. So is this receipt of fund treated as deposit? Answer is no. This is not a deposit. Are you getting the point what I'm saying? Everybody? Yes. So this is receipt of fund for the company. So if director is giving money to the company in the form of loan or whatever, that receipt of fund is not a deposit. Okay. But what if director borrows money from anyone, let's say for example bank. Okay, director has borrowed money from bank and director gave that borrowed money to the company. In the first point I told you, director gave money to the company, that is he gave money from his pocket in the form of loan. So that receipt of fund is not a deposit. Okay, but if director has borrowed money from bank and that amount director gave to the company, okay, so that receipt of fund is treated as deposit. Okay, so if director is giving money from his pocket, it is not a deposit. But if he is giving money which he has borrowed from someone, that amount, that receipt of fund shall be treated as deposit. Easy? No, that he has to give declaration. You have not studied the rules, beta. You have to give an app. Whenever you give money, you need to give in the form of deposit. You need to give a declaration that this amount is my money or borrowed money, whatever. That means he is not doing his duty. He is not following the rules. Do you know there is a penalty for that? So that will be applicable. Simple. So if director is giving money from his pocket, it is not a deposit. If he has borrowed money and given to the company, it is a deposit. But there is a note also. In case of private company, funds receives, if a private company receives fund from relative of director, such amount is not a deposit. See, understand now, please don't get confused. Firstly, tell me, first point, if director is giving money to the company, so company has received money from the director, is there a deposit? No. Okay. Okay, if company receives money from relative of director, public company, come on, public company, if money is coming from director, not a deposit. If money is coming from relative of director, is it a deposit? Is it a deposit? Public company, is it a deposit? Yes. Come on, now private company. Private company is receiving money from director. Is it a deposit? So if company is receiving money from director, it is never a deposit. Okay. But in case of private company, if company is receiving money from the relative of director, is there a deposit? Is it a deposit? So friends, that is not a deposit, but that is only in case of private company. You know, private company enjoys certain relaxation. So this is one of them. Okay, clear everybody? Now next, point number 6. Now if company receives funds from someone by investors, proposed investors, by issue of bonds or debentures. Come on, company has received funds by issuing bonds or debentures. So company has received funds. So this is receipt of funds which company has received by issue of bonds or debentures. So come on, debentures money, that is called as borrowed capital. Is that receipt of fund a deposit? Is it a deposit? Is it a deposit? Answer is no, it is not a deposit if conditions are satisfied. Okay, so what are the conditions? Let's see. So are you getting the point? So if company has raised capital by issue of debentures, that receipt of fund is not a deposit if conditions are getting satisfied. What are the conditions? Let's go. First, that debenture must be secured debenture. Debenture must be secured debenture. Second, security must be created on the tangible property of company. Okay, the value of property must be more than or equal to the repayment amount of deposit. Okay, shall be more than or equal to the repayment value of deposit. Okay, and the value, who will determine the value of property? Registered valuer. There are 4 conditions. If there are four conditions are getting satisfied, then the amount borrowed, yes, by issue of debentures or bonds, such receipt of fund is not a deposit. Conditions: debenture must be secured, security must be created on the tangible property, the value of property must be more than or equal to the repayment amount of deposit, that is with interest, and who will determine the value? Registered valuer. Okay, is this clear to everybody? Very easy. Yes. Okay, so we are very clear that if debenture is secured, then borrowed capital is not a deposit. Correct? Fine. But what about if debentures are unsecured? company raises money by issuing unsecured debenture, then is it a deposit? So in general sense, yes, it is a deposit, right? But can you see here, or means debenture must be secured or compulsory convertible debenture, or debenture must be what? Compulsory convertible debenture. I hope you know there are different types of debentures. So if the debentures are compulsory convertible debentures, means what is this? Company has raised money by issuing compulsory convertible debentures, one of the type of debentures. That means the company has borrowed money, and see, generally in debentures, when company has borrowed money, company have to redeem the debentures. Means company have to repay the money back to the investors with interest. Correct? But if debentures are a type of compulsory convertible debentures, means at the time of maturity, company will not repay the money. Company, instead of repaying the money, company is going to convert those debentures into equity shares. Means instead of making the repayment of money, company is going to issue them equity shares, convert the debentures into equity shares. Okay, so yes, so that is the point here. Debentures must be secured or it must be compulsory convertible debentures. That debentures must be converted into equity shares within a period of 10 years from the date of such issue. So now let us conclude this point. If company has borrowed money by issue of debentures, such receipt of fund is not a deposit if such debentures are secured or such debentures are compulsory convertible debentures. Only then such receipt of fund is not a deposit. Easy everybody? Debenture must be what? Secured or compulsory convertible debenture, then it is not a deposit, otherwise it is a deposit, right? Clear everyone? Okay, now see the next point. Next point is, if company has received funds by issue of unsecured non-convertible debentures. See, in the previous point what we have done, if the debentures are secured or compulsory convertible, then it is not a deposit. That means if debentures are unsecured, non-convertible, then it should be a deposit. Yes or no? But see the next point. Next point says that if company has raised funds by issue of unsecured non-convertible debentures, such receipt of fund is not a deposit. Yes, can you see here? Here we are talking about unsecured non-convertible, should be a deposit, right? But this point says that if the debenture is unsecured non-convertible, then that amount is also not a deposit. It is not a deposit. Are you getting my point? Everybody understood that? So both the things are not a deposit. Okay, both the things are not deposit if conditions are getting satisfied. So if the debentures are secured or compulsory convertible, it is not a deposit. Okay, and here it says that if the debenture is unsecured and non-convertible, then also receipt of fund is not a deposit if conditions are satisfied. What are the conditions? Conditions are debentures are listed on recognized stock exchange and debentures were issued as per SEBI regulation. Then it is not a deposit. Otherwise it is a deposit. Suppose if company raise funds by issue of unsecured non-convertible debenture. Such debentures were listed on recognized stock exchange, but company has issued those debentures in violation of SEBI regulations. Come on, is it a deposit? Yes, it is a deposit because conditions are not satisfied. Is this clear to everybody? Okay, here there is a question. What if debentures are secured but non-convertible? So dear, here already we have covered this part. Can you see this first part? This part is about secured debentures, right? Or compulsory convertible. So it is very clear that if debentures are secured itself, you are asking about secured. So if they are secured, so it is not a deposit. Very simple. Okay, because it is or in between. Okay, yes, 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 because you have seen that section 71 which talks about debenture. It says that debenture includes bonds. Okay, yes. What is next? Now the next point is point number 8. Now see what is here. Company has received funds. Company has received funds from its employee in the form of security deposit. Obviously, this is not the deposit what we are talking about. It is a security deposit. So if employee has kept X amount with the company in the form of security deposit, so is company having some money? Yes. So is this receipt of fund? Yes. So this receipt of fund is not a deposit. Okay, provided the amount which employee has kept with the company in the name of security deposit, that amount shall not exceed annual salary of employee. Only then it is not a deposit. Okay, and amount shall be given non-interest bearing. Is this clear? Yes. Okay, there is one more doubt. Okay, so means from the same person. So means all types of issue of debentures are not considered as deposit. Beta, all types of debentures are not deposit if conditions are satisfied. If you have seen that for secured debentures there are different conditions. For compulsory convertible there is a condition that conversion should be done within 10 years only. For unsecured non-convertible there is a condition. So accordingly you have to consider whether it is a deposit or not. Okay? Fine. I gave an example so in class that if the debentures are issued which are unsecured, non-convertible, they are listed on recognized stock exchange, but they were issued in violation of SEBI regulation. So when I say it is in violation of SEBI regulation, that means condition number 2 is not getting satisfied. So therefore it is a deposit. Okay, yes, we come back to this point now. So employee has given some amount to the company as a security deposit. So that receipt of fund is not a deposit if conditions are getting satisfied. What are the conditions? Come on. First, the amount which employee has kept with the company as a security deposit, that amount should not exceed his annual salary. Only then that amount will not be treated as a deposit. An amount is given non-interest bearing, means amount which employee gave to the company is without any interest. Okay, so in that case it is not a deposit, otherwise it is a deposit. Next, company is holding funds as a trustee. What is trustee? Means company is holding fund as an agent. So if company holds the money, company has received some amount, it is receipt of fund. Okay, but company is holding the money as a trustee, as an agent. Okay, so that receipt of fund is not a deposit. It is not a deposit. Condition, the amount given to the company was non-interest bearing, that is without any interest. Then it is not a deposit. Otherwise, it is a deposit. Very simple. Then next. See, now every company is doing some type of business. Yes or no? Company may either sell goods or provide services. Right? In return, they want money. So what if company gets some bulk order? So obviously company is going to ask for advance first, right? So if customer gives an X amount to the company, company receives funds as an advance in the ordinary course of business. Are you getting my point? What I'm saying? Yes. So if company, okay, there is one doubt here. सर सेक्शन 19 में भी ट्रस्टी वाला पॉइंट था बेटा. इन सेक्शन 19 दैट इज इन चैप्टर मेंबर्स एंड शेयर होल्डर्स, ट्रस्टी इज यूज्ड एट मेनी प्लेसेस. ट्रस्टी वाला पॉइंट बहुत सारे जगह पे यूज होता है. ओके, एंड सेक्शन 19 व्हाट यू टॉकिंग अबाउट इज, इन दैट केस इफ यू रिमेंबर, क्या बोला था कि कंपनी कैन बिकम मेंबर ऑफ अनदर कंपनी? आंसर इज यस, बट सब्सिडरी कंपनी एज पर सेक्शन 19, सब्सिडरी कंपनी कैन नॉट होल्ड शेयर्स ऑफ इट्स holding company. That is a totally different thing. We are not talking about here, we are not talking about holding shares We are talking about receipt of funds. And trustee is a common word which is used at many provisions, in many provisions. Okay, so please don't get confused. Okay, chalo, let's go. So here we come back to this point. So if company receives funds from customer, so company is receiving funds in the ordinary course of business. Friends, what is this ordinary course of business? That is in the way of doing business activity, right? That is for supply of what? Supply of goods or services. Okay. For the supply of goods or services. So friends, if company has received an X amount as an advance for the supply of goods and services, that is in the ordinary course of business, company has received advance? Yes. Is this receipt of fund made by the company? Yes. This is not a deposit, because see, you will say obviously sir, why this will be a deposit? This is an advance which company has accepted in the business activity. Yes or no? Yes or no? Yes or no? Arey no, listen to me. See, this is not a deposit. Okay, why this requires a clarification here? Because what does definition say? Definition is saying that any receipt of fund is treated as deposit. So if we don't mention it here, then it will be automatically become deposit. Therefore, it is specifically given in rule 2, that is in the list of exclusion. So advance received in the ordinary course of business for providing goods or services is not a deposit if conditions are getting satisfied. Condition is very simple, that you should utilize this money, you should adjust this money in the purpose for which you have raised the money. So you have raised the money for what purpose? For supplying goods or services. So kindly supply the goods and services. Yes, can you see this? This advance money received must be adjusted against the goods and services, that is company should supply the goods and services within a period of 365 days. Is this clear? Yes, and in case of dispute, the 365 days rule is not applicable. I hope you understood this. Company have to provide goods and services within a period of 365 days. What if company has received advance money and company has not adjusted that money against the supply of goods and services? So is that a deposit? Yes, then it is a deposit. And you saw that point, in case of dispute, it is not applicable. What is that in case of dispute is not applicable? Suppose if there is a dispute between company and customer, okay, with regard to some goods or services, and company has already received advance. Now that advance is treated as deposit or it is not treated as deposit? It is a deposit or it is not a deposit? It is not a deposit. Even if company does not supply goods and service within 365 days, because there is a dispute. So company will not supply goods or services until and unless the dispute is resolved. Okay, so that is the point. Okay, yes. Okay, so doubt in the live chat, there is separate point for this. We will talk about it. You will see that point now very soon, don't worry. Because whatever you are asking, that is not applicable in this point. Okay, this is only for supply of goods and services. We will talk about your point. This is your doubt is about long-term projects. So there is a separate point for long-term projects. Okay, chalo, what is next? Next point is, suppose this is a property of company Okay, and what company is going to do? Company is going to transfer this property. Company is going to sell this property to someone. Okay, now this you can see here, Mr. Kaju, he wants to buy the property of company. So what he did, he liked the property. So what he did, he paid some advance money to the company because he want to buy this property, and company has received, that is receipt of fund, company has received that advance money as a consideration for transfer of immovable property, because company is going to transfer the immovable property. Correct? So for that purpose, if company receives any advance, such receipt of fund is not a deposit. Such receipt of fund is not treated as deposit. Condition? Come on, purpose for which company has raised money, that purpose should be fulfilled. What is the purpose? Company is going to transfer the property. So company now accepted advance money. So now company should transfer the property as per the agreement only. Right? So property shall be transferred as per the agreement. Property must be given as per the agreement. Is this clear to everybody? Okay, what if company has received money as a consideration, advance money as a consideration for the purpose of transfer of property? Correct? Now friends, what if company does not transfer the property after receiving advance? Then that receipt of fund will be treated as a deposit. Okay, next. Yes, here the doubt which was raised, last doubt which was raised in the chat box, here is the answer for your doubt. Please concentrate. Now see friends, if company has received some advance, okay, from its customer, from its client. Now if company has received advance money, for what purpose this time? This is for long-term projects, performance of contract, for supply of goods or services. Okay, so if there is a contract, that is long-term projects, performance of contract. Okay, so in such case, if company has received some advance from its client or customer, so obviously again company is receiving money, that means this is what? This is receipt of fund. This is receipt of a fund. This receipt of fund is not a deposit. This receipt of fund is not a deposit. Are you getting my point? So, you know, in the previous point which we did, in the 10th point, you saw, there we were talking about 365 days. That company have to adjust the money within 365 days. But here you saw what was the case? Here you saw the contract is long-term contract. So in that case, the advance money received by the company is not a deposit. Okay, so the doubt which was asked in live chat, that was if the construction company taken advance of a project, but construction is not completed within 365 days, so it will be treated as deposit within after 365 days. So obviously answer is no. Okay, no construction can be completed within 365 days in most cases. So obviously that is not a deposit because it is a long-term contract. Okay, clear? Yes. And if you're talking about some house property, so I hope you know there is something called as RERA Act also. So there is a separate law for that also, but if deposit point of view, this point is applicable on your question. Okay, so I hope you have got your answer. Let's proceed further, everybody. Next point. Now this time, what it is? Company has received advance money once again towards consideration for providing future services. Company has received advance. You know, there are maintenance contracts. There are maintenance contracts, there are warranty contracts. You know, like many times the person who is coming from any servicing company, he may sell you the annual package for AC servicing. Then he can sell you this water purifier, this annual package, annual maintenance package. So he will ask you to pay money today only for the entire year. Now in that year he will provide you 4 services, 3 services, depends on your package. Correct? So tell me, has company received the amount right now? Yes. So that is receipt of fund for the company? Yes. Company has receipt of fund, right? But that receipt of fund is for what? For providing future services. You are paying right now for the entire year. He may come in future and provide you services 3 times, 4 times, depends on your package. So the advance money received towards providing future services, that is maintenance contract, warranty contract, that receipt of fund is not a deposit if conditions are getting satisfied. So this is very much clear. That is not a deposit. Conditions. What are the conditions? That agreement must be in writing. That agreement must be in writing. Which agreement? Agreement between company and customer. That is agreement must be in writing. Okay. Future services shall be provided as per the common business practice or 5 years, whichever is less. You can say whichever is earlier. Like for example, if we talk about AC servicing contract, annual maintenance. So obviously that in that industry, what is the duration which is generally accepted as a common business practice? That is annually, that is 1 year. That means service must be provided within 1 year or 5 years, which is written in the law. Whichever is earlier. So what is earlier? 1 year. That means amount which is raised by the company in the form of advance must be adjusted within a period of 1 year. Means company should provide all the future services within a period of 1 year. Then that receipt of fund is not a deposit. Otherwise it is a deposit. Okay. Chalo, fine. What is next? Now, again, next point says that if company received funds from any of the sectoral regulator as per the directions of government, by whatever reason, if company is receiving money from any of the sectoral regulator, you understand sectoral regulator? Who? RBI, SEBI, all the regulators, IRDA, right? All these are the regulators, TRI. So yes, if company is receiving any of the funds from any of these regulators as per the directions of government, so company has received funds. This is receipt of fund. So that receipt of fund is not a deposit. Very simple. Next is Nidhi company. You all know what is Nidhi company. What is the purpose of Nidhi company? What is the object of Nidhi company? Accepting deposits and lending money from and to its members only. Correct? So here you can understand it is a daily activity of Nidhi company. So if Nidhi company receive funds from its members as per its object under section 406, such receipt of fund is not a deposit. Such receipt of fund is not a deposit. Very simple, because that is its daily activity. Next is, if any person makes a payment to the company for subscription towards a publication, okay, in print media or electronic media. Are you getting the point? Come on, company has received an X amount because you want to subscribe to the publication of company in print media or electronic media. Example I gave you in class, that whenever you were going for your ICSI CS executive registration, that time you had an option to subscribe to the chartered secretary, right? So you have to pay 500 rupees to the institute for that. So if institute has received that 500 rupees, that is receipt of fund which you have paid for subscription towards the publication. Correct? So that receipt of fund is not a deposit. It is clarified here. It is not a deposit. Okay? Yes. Now next point. Point number 17. What is it saying? Everyone. See, if company has received advance under point number 10, 11 and 12. These are point number 10, 11 and 12 as per my notes. Okay, so let's go with it. Once again, point number 10, 11 and 12. Here it is. You saw here company has received advance money for supply of goods and services. That was point number 10. Then point number 11 was company wants to transfer its immovable property and therefore company has received advance. And point number 12 was long-term projects. Company has received advance, that is for the long-term, in the form of long-term projects. Okay, so now in all these three, okay, if company has received advance under point number 10, 11 and 12 with or without interest, the company has received advance. But company has accepted money for which company do not have necessary permission. Company has accepted money under point number 10, 11 and 12 circumstances, but company has not obtained the necessary approval, necessary permission. For the purpose, company has raised money, company don't have necessary permission. Example is, company has raised money for supply of food stuff, but company don't have food license only. So in that case, what company will have to do? Company has accepted money for the wrong business? Yes. So what will company have to do now? Company have to refund that money. That amount becomes refundable. Okay. Company have to refund that money within a period of 15 days. If not refunded in 15 days, then that receipt of fund shall be treated as deposits. Okay, so that amount becomes refundable which company has accepted under point number 10, 11 and 12. Okay, yes, but company do not have necessary permission for that thing. So that receipt of fund is a deposit if not refunded within 15 days. Now point number 18, everyone concentrate please. Here, very important point. Yes. Chalo. Now point number 18. What it is saying? See, now company has received funds. Company has received funds in the form of unsecured loan. Okay. Company has received funds from promoter of company or relative of promoter or both. If company has received funds from promoter or relative of promoter or both. Okay, so if company has received funds from any of them, such receipt of fund is not a deposit. If company has received fund from them, it is not a deposit. Is this clear to everybody? It is not a deposit. This was first point. Okay, but second point. What if promoter or relative has borrowed money from somewhere, let's say for example from bank, and that amount they gave to the company? What do you think? Is this a deposit? Is this a deposit? That depends on something. Come on, once again. In the form of unsecured loan, if promoter or his relative or both has given some funds to the company in the form of unsecured loan, such receipt of fund is not a deposit. But if these people have borrowed money from bank and gave that fund to the company, so such receipt of fund is a deposit or it is not a deposit. If they have borrowed money and give it to the company, is it a deposit or it is not a deposit? So answer is, it depends on something. What it is? Suppose if for example promoter or relative has borrowed money for 5 years. Example, they have borrowed money for 5 years. Okay, or let's say 2 years, whatever example you want to take. So if let's say 2 years, okay, so if promoter or relative has borrowed money from bank for 2 years, now that amount they gave to the company. Now the question is, company is holding that money for how much time? That is the question. So if company retains that money, company holds that amount only till the repayment of loan is made to the lending institution, that is bank. You understood? If company retains the amount only till the repayment amount of loan is made to the lending institution, means obviously promoter or relative will make the repayment of loan to the bank. So if they repay the loan, let's say in 2 years, so company had received the same funds. So if company is holding that money only for the 2 years time, companies retains that money only for the period of 2 years, only till the time the amount is repaid to the lending institution, then such receipt of fund is not a deposit. But if company retains, holds such amount even after the loan is repaid to the lending institution, means if company retains that amount, if company holds such amount even after the loan is being repaid, now when will they repay the loan? Let's say in 2 years. But company holds that money even after the loan is being repaid. Let's say company holds the money even after 2 years. So that receipt of fund made by the company is a deposit. Is this clear to everybody? Yes, no? Which point? Beta promoter, this is very specific, this is unsecured loan. Any funds received from the director tha wo, not promoter. Promoter is different, director is different. Right? Clear everyone? So this is your point number 18. Now few small points, then it's over. Come on. You have these notes, na? Chalo. Now, so what is next? Next point is, if company received funds in respect of chit fund, there is an act for it, Chit Fund Act 1982. So in the form of chit fund, if company receives funds from any person, such receipt of fund is not a deposit. Such receipt of fund is not a deposit. Okay. Next is, if company received funds from any person under CIS as per SEBI regulation. What is CIS? Collective Investment Scheme. So if company received funds under CIS, such receipt of fund is not a deposit. Such receipt of fund is not a deposit. Because it is allowed as per SEBI regulation, there are separate rules for that. So it will be not be treated as deposit. The next is, if company received funds from AIF, Alternative Investment Fund, Venture Capital Fund, Infrastructure Investment Fund. So if company receives funds from any of the following as per SEBI regulations, SEBI compliance, so that receipt of fund is again not a deposit. You people have already studied the separate law for all of these. Correct? So it will not be covered under deposits definition. Okay, what is next? Next is, last point for this definition is, if a startup company receives funds. If startup company receives funds, what fund? 25 lakhs or more. If startup company receives funds of 25 lakhs or more by a convertible note in a single transaction. Okay, I hope you know what is convertible note. Company has received raise funds. Company has received investments. In return, company have to allot what? Equity. But equity can be allotted only when we are clear about the valuation of company. If company has received, let's say 10 lakh rupees as investment, 1 crore as investment, so in return company have to give equity. So how much equity company should allot? That depends on the valuation of company. But right now, let's say for example, it is difficult for us to determine the valuation of that company. It is now, the business is very uncertain. Okay, so right now funds are received by startup company, but are we allotting equity right now? No, because valuation is not clear. Okay, so now what we will do, we will raise the money in the form of convertible note. So now right now company will get the money and company will give what? Convertible note. Means in future, whenever there will be clarity about the valuation part, then In future, suppose if you have given 1 crore rupees, so what is the valuation? Let's say for example valuation is 2 crore only. You have given 1 crore. So 50% equity should be given to you. So then those money will be converted, that note will be converted into equity shares in future. Understood this much? It is different thing beta, I'll tell you. You understood this much? So company has received funds that is in the form of convertible note in a single transaction. Okay, that's all. Fine. Now how much funds company has received? Company has received funds of 25 lakhs or more. So tell me, if company has raised money 25 lakhs or more, is this receipt of fund for the company? Yes. This receipt of fund is not a deposit, obviously. This is not a deposit, obviously. Correct. Now friends, you know what? This is not a deposit for how much time? 10 years. You know what? The startup company has relaxation in compliances for a period of 10 years. After 10 years, if 10 years from the date of incorporation. After 10 years from the date of incorporation, if company is doing this, then this receipt of fund will be treated as deposit. Because the definition says any receipt of fund. Correct? I hope this is clear to everybody. Yes. Any doubt in this? So your entire definition is over. I know what I have written. Beta, it's just saying that the remaining chapter is in the separate file. Okay, so definition is clear, everybody? Yes, can we go ahead? Or online students, definition is clear? Yes, so we are done with the definition in 22 points. Now we will go with the rules of this deposit chapter, and the rules and sections we are going to do from your ICSI module. I use this file only for the definition. Okay, so let's take out the module now. With your module, please take out your module, everyone. Debt instruments chapter, part B, deposits. Chalo. Now, debt instruments module is ready. Now in this module, part A, as you know, that talks about borrowed capital, right? But we need to go to part B, that is deposits. Here it is, part B. Okay, let's go. Chalo. Now, so already definition section 2 clause 31, right? Read with rule 2, right? Sub rule 1. So we have already done with how many points? 22 points. I told you in your module that definition is given in 18 points. So these are the 18 points in front of you, which we have already done with example. Okay. Yes, this 18 points. Now we are moving forward. What is next, friends? So next is, what is the meaning of depositor? You know, friends, the person who subscribed the shares is called as shareholder. The person who subscribed debentures is called as debenture holder. Person who makes an investment in the company in the name of deposit is called as depositor. Who is the depositor? You know what? Okay, come on. Before moving to this part, tell me which companies can accept deposits? Which companies can accept deposits? You know what? Obviously, every company can accept deposits. See, understand. Which companies can accept deposits? Okay, so tell me, can private company accept deposits? Yes, private company can accept deposits. But you know what? Private company can accept deposits from public? No, private company can accept deposits only and only from its members. Okay, yes, from members, yes, from public, prohibition. Correct. Okay, what about public companies? Can public companies accept deposits? Yes. Can all public companies can accept deposits? Yes. Can public company accept deposits from public? Can public company accept deposits from public? Yes, no. All public companies cannot accept deposits from public. Only eligible public company can accept deposits from public. Because there are two types of public company here. What are the two types? One is eligible public company. Eligible public company. And next is non-eligible public company. There are two types. Okay. So, eligible public company can accept deposits from public? Yes. Non-eligible public company? Non-eligible public company cannot accept deposits from public. Non-eligible public company can accept deposits from its members only. From its members only. Are you getting my point? Everybody? So private company from members. Public company can accept deposits from public, not all public company, but it is public eligible company. So only public eligible company can accept deposits from public. Non-eligible public company cannot accept deposits from public. It can accept deposits only from its members. Okay, so this is the thing. Now let's go forward. One more thing, please pay attention. In the deposits chapter, whenever we will talk about acceptance of deposits from members, that time we are going to talk about section number 73. And when company is accepting deposits from any other person, means other than members, that is from public, then we are going to discuss section number 76. You know this chapter, it is from 73 to 76. But these two sections, 73 and 76, 73 talks about acceptance of deposits from members and 76 talks about acceptance of deposits from public. Clear everybody? So this is the case. Okay, so let's go with the module now. Here it is, come on. Who is a depositor? So there are two possibilities. First, member, and another is any other person. When we talk about acceptance of deposits from member, means what? Section number 73. From any other person means section number 76. So who is a depositor? Member of company who has made a deposit with the company as per section 73 is a depositor. Any other person who has made a deposit with the public company as per section 76 is also a depositor. Okay, easy. Now So just now I showed you that there are two categories of public company, eligible and non-eligible. So what is the meaning of eligible public company? So here we go, the meaning of eligible public company. Eligible public company means a company having net worth of not less than 100 CR or more, or turnover of not less than 500 CR or more. Are you getting the point? Everybody? Eligible public company is a company having net worth of 100 CR or more, or turnover of 500 CR or more. Then only your public company is called as eligible public company. And I hope you know, only then you can raise money from public in the name of deposits. So what is non-eligible public company? Non-eligible public company is a public company which does not satisfy the requirement of this paid up share capital, net worth or turnover. Net worth is 100 CR or more, turnover is 500 CR or more, any one. Easy? Okay, so this is the meaning of eligible company. Okay, now can I say now company is accepting deposits means in a way company is borrowing funds? Yes or no? In a way company is borrowing funds. Yes. Do you remember section number 180? Restrictions on the power of board. Restrictions on the power of board. Do you know in section 180, which we did in the chapter board composition, restrictions on the power of board, in that case there was one point number 3, that if company makes the borrowing beyond the limit, yes, correct, if company makes the borrowing beyond the limit, company is required to pass SR, because that is restrictions on the power of board. Means board cannot take the decision. Board is required to obtain approval of shareholders, that is by passing SR. Correct? So here we are talking about the same thing, that if company is accepting the deposit beyond the limit, then company have to pass special resolution. Can you see this? Company is required to obtain prior consent in general meeting by passing SR, and also need to file the same with ROC, that is MGT 14, before making invitation. Okay, clear? Yes. And SR is required basically. And if company is accepting deposits within the limit given in 180, if it is within the limit and company wants to accept deposits, then company can do this by the means of passing ordinary resolution itself. Is this clear to everybody? So if I ask you, company is accepting deposits, eligible company is accepting deposits from public, which resolution is required? OR or SR? Generally OR. Beyond the limit, SR. Beyond the limit, which limit? Limit which is given in deposit rules? No, limit which is given in section 180. Clear everybody? Sure? Okay, let's go further now. Now, next is prohibition on acceptance of deposits from public. As I told you, only and only which company? Public eligible company can accept deposits from public, no other company. Okay, can you see this? No company can accept renew deposits from public except in the manner given in the chapter. Except in the manner given in the chapter. Okay? Yes. Now friends, you know there are few companies which are exempted from the regulatory framework of this chapter. Come on, what is regulatory framework of this chapter? Section 73 to 76 and Companies Acceptance of Deposit Rules 2014. Correct? Come on. There are few companies which are not required to follow these sections and rules. Why? Means there are few companies which are not going to follow the deposit rules. Why? Because these companies accept deposits, accept money in their ordinary course of business. Therefore, that receipt of fund made by them is never a deposit. So which are the companies? First is banking company. Second is NBFC, right, as defined in the RBI Act. Then housing finance company registered with NHB. Then such other company as central government specify in this behalf. So all these companies are not required to follow the regulatory framework of this chapter, deposits. Easy. So this was about non-applicability. Okay, before that we did what resolutions are required for eligible company, and now we are starting with section number 73. Come on, tell me, 73 means what? Acceptance of deposits from members. So here we are going to talk about the terms and conditions for acceptance of deposits from members. Is this clear to everybody? Yes. So we will continue this. Just take 1 minute break. Chalo, break up. Let's continue. So, terms and conditions for acceptance of deposit from members. Okay. See, when we talk about members, do we need to issue prospectus? We issue what? Circular, letter of offer, all these things, right? So see the points now. Everyone please concentrate what I'm saying. Company may accept deposits from its members, okay, on such terms and conditions, okay, the following. Here they have written the same thing in very small manner. Here is the detailed part. So in the following conditions, first, what company is required to do? First, company has to issue circular to its member. Instead of prospectus, here we are going to issue circular. You know, circular means that kind of prospectus, means have all the details of terms of issue and everything. Okay, this circular prospectus must be in which format? It must be in format DPT1. Okay, so please understand, first thing companies need to do is issue circular to the members. Now in that circular, you also need to include a statement showing financial position of the company. You understood? Statement should show the financial position of the company. Okay, so that accordingly depositors will make the decision. Then also you need to obtain credit rating. Also you need to mention the total number of depositors of company. All these things need to be mentioned where? In the circular. Come on, total number of depositors, total amount due towards the deposit in respect of previously accepted deposits by the company, and such other details in form DPT1. DPT1 is a format. Okay, everybody understood what is the first thing you need to do is issue of circular to the members, including all these things. First thing is statement showing financial position. Then you also need to mention what? Credit rating, which company has obtained, total number of depositors of company, right, and total amount which is due towards the deposits. So these four things should be in the circular in form DPT1. Okay, easy. Come on. Second step is, you know, before issuance of this circular prospectus, always company have to do what? Company have to first file this with ROC. Company have to file this with ROC. File a copy of circular with ROC 30 days before the date of issue of circular. That is for approval, for registration. Okay, so you have filed this with ROC 30 days before the issuance of circular. Okay, now one more thing is, you know, company have to maintain a separate bank account. Company have to open a separate bank account in a scheduled bank, and that bank account name shall be named as DRR account, that is deposit repayment reserve. Why this account is to be opened in a separate account in a scheduled bank? Because I hope you all know, yes, at the time of repayment there should not be any problem. So company have to, on or before 30th of April each year, company have to deposit the amount not less than 20% of the deposits getting matured in the following financial year. So whatever deposits are getting matured in the following financial year, out of the total amount, at least 20% of the amount should be transferred to this separate account to be opened in a scheduled bank. At least how much? 20%. When? On or before 30th of April every year. Means every year company have to look after this, on or before 30th of April. Okay, clear everybody? So this also should be noted. DRR account to be opened in a scheduled bank. Not less than 20% of the deposits getting matured should be transferred in that separate account. Okay, next point, company have to give a declaration. Certify that company has not committed any default in the repayment of deposits which were accepted either before the act or after the act, or payment of interest on such deposits. You understood that? Company have to certify that. Company have to give the declaration that we have not made any default on the repayment of deposits or its interest which we had accepted previously. And even if the default has been occurred, company has made good the default and period of 5 years has been lapsed since the date of making good the default. So you have to give this declaration also. Also, company have to create a security. You all know that creation of charge. So company have to provide security. Clear everybody? What is security? Company have to create charge in one of its property. Right? So you can see creation of charge on the property or assets of the company. That is for the repayment of deposits or its interest. Easy? Any doubt in this? What if company does not create charge on its assets? On its assets? If company does not secure the deposits, company does not create the charge, such deposits shall be termed as unsecured deposits. Such deposits are called as unsecured deposits. I hope this is clear to everybody. 5 points. This is related to acceptance of deposits from members. Everybody clear with this? Any doubt? Okay, first point. Can we revise once? Come on, we are talking about acceptance of deposits from members. First thing company needs to do is issue circular containing what? Statement showing the financial position of the company, credit rating obtained by the company, the number of depositors of the company, total amount due towards the deposits. Right? This circular should be in format DPT1. Next, company have to file the copy of circular with ROC within 30 days before its issuance. Then third point, on or before 30th of April every year, company have to deposit at least 20% of the total deposits getting matured in the following year in a separate account to be opened in a scheduled bank. So on or before 30th of April, company have to transfer this amount in DRR account. Okay, then company have to certify that company has not committed any default in the repayment of deposits or its interest. Okay, and even if the default was made, the default has made the good and period of 5 years has been lapsed since the date of making good the default. Okay, and last one is providing security. Charge should be created on the property to create security. And if it is not created, such deposits are called as unsecured deposits, and it's done. Over? Easy? Yes? 5 points over? Over. Now, next is acceptance of deposits on the basis of time period. What is this? Here we are going to talk about duration of deposits. Okay, now you saw the definition. So if company has received money by this way, it is not a deposit. If company has received money by this reason, it is a deposit. So suppose if the receipt of fund is a deposit as per the definition, so what do you think? What shall be the rule? In that case, we said that regulatory framework shall be applicable. What will the regulatory framework say conceptually? What company needs to do now? Company have to pay interest. Right? That will be the concept. What else? So if there is receipt of fund, company is required to pay interest on such deposits, right? But if there is a receipt of fund, and if this receipt of fund is a deposit, this receipt of fund is a deposit, so what will company do? Now company have to pay interest. Oh no, what will company do now? Company will return that money immediately. Company will say, no, we don't want deposit. Oh, take it back. Company will refund it. But can company do that? Answer is no. Why? Because once a receipt of fund is treated as a deposit, there is a minimum period of deposit. Means company has to pay interest for at least minimum period. So what is that minimum period for which company have to accept deposits? So that is 6 months. Minimum period is 6 months. Minimum period of deposit is 6 months. Okay. Now, company can accept deposits for maximum how much period? That is 36 months. Minimum period of deposit is 6 months. Maximum period for which company can accept deposit is 36 months. Sir, what after 36 months? Obviously, after 36 months, company can renew it. Okay. But minimum period is 6 months, maximum period 36 months. Easy, everyone? Okay, yes. Now question is, minimum period is 6 months. Can company accept deposits for less than 6 months? Because 6 months was a minimum period. So can company accept deposits for less than 6 months? So answer is yes, but there are conditions. Come on, my question is, can I give an X amount, can I invest an X amount in the company in the name of deposits for 10 days? Can I give an X amount to the company for a period of 10 days in the name of deposit? Can I give it in the form of deposit for 10 days? Obviously, minimum period is 6 months. So, can deposits be accepted for less than 6 months? Yes, but obviously there are conditions. So, condition says that not less than 3 months. So, minimum period will be 3 months in that case. If it is for less than 6 months, it is okay, but not earlier than 3 months. Are you getting the point? Can you see these two conditions? Can you see this? Not earlier than 3 months. So if it is for less than 6 months, it is okay, but not earlier than 3 months. And there is one more condition, that if company is accepting deposit for less than 6 months, okay, so there is a maximum amount limit which company can accept. So company can accept maximum 10% of paid up share capital, free reserves and security premium. The amount shall not exceed 10% of paid up share capital plus free reserves plus security premium. So this is the two conditions which company need to follow if company is accepting deposits for less than 6 months, that is earlier than 6 months. Duration of deposit is clear, everyone. You can write this heading if you want in your module so that you are familiar with the terms. And this was your rule number 3. See, in this chapter, sections are obviously important to you need to mention in your answer sheet, but also in this chapter you need to know the rule number. Like duration of deposit is given in rule number 3 of company's acceptance of deposit rules. What was given in rule number 2? That list of that in that list excluding list which is not a part of deposit, which was a part of definition. Come on, can deposits be accepted in joint names? Yes, but not more than 3. Okay, very simple. Yes. Now here it is acceptance limits for deposit. What is this? Here you can write maximum limit for acceptance of deposit, or you can write maximum limit of deposits. The previous topic what we did was the time. Now we are talking about the amount limit. Okay, so companies can accept deposits, true, but what is the limit on the amount? Okay, what is the limit on the amount? Okay, so let's go with it. Firstly, the paragraphs which you can see here, the same thing is given here in tabular format. Come on, first we will talk about eligible company. Come on, can eligible company accept deposits from members? Yes. From public? Yes. So you know, in all total limit is 35%. In all, for all the companies generally, the limit is 35% of paid up share capital, free reserves plus security premium, right? But for eligible company, they can accept deposits from members as well as public. So how much they can accept from members and how much they can accept from public? Total is 35%. But what is the bifurcation? So they can accept maximum 10% of paid up share capital, free reserves and security premium. 10%, okay? 10% of aggregate from the members and 25% of aggregate from public. Okay, is this clear, everyone? Okay, so this is about eligible company. Now what about non-eligible company? Do you know non-eligible company cannot accept deposits from public? So for public it is prohibited. But can they accept deposits from members? Yes. So what is the limit? 35% of all the 3. Third is government company. Yes. Government company, which is an eligible company, can accept deposits from public. How much? 35% of all the 3. Okay, so this was your quantity of deposit. Can you see there? quantum of deposit, which means quantity. Okay, so this is the maximum limit which company can accept in the form of deposits. Yes. Now, see this. Exemptions to specified IFSC public and private companies. Generally, you saw the limit was 35%, but the specified IFSC companies, which may be in the form of public company or private company, right? But the specified IFSC companies, they can accept deposits from its members not exceeding 100% of paid up share capital plus freezers plus security premium. You understood? For them, the limit is 100% of all the three. Therefore, it becomes an exception. 100% of all the three. Okay? Yeah, that is also the case. But here we are talking about specified IFSC, public company and private company. Easy? Okay? Next. Now, see this, friends, everyone. The maximum limit rule, what we did just now. The maximum limit rule is not applicable on following class of companies. See, just now we did, private companies can accept deposits how much? Private companies can accept deposit 100%. And specified IFSC, public company 100%. Correct? So the limit for them is 100% and other companies limit is 35% and so on. But friends, now I am talking about the exception rule, that is the maximum amount of deposit rule shall not apply to the following class of private companies. There are few companies on whom the maximum limit rule is not applicable, means they can accept deposits whatever amount they like. So what are the companies? Which are those companies? First is startup company for a period of 10 years from the date of its incorporation. So startup company, no restrictions on the limit. Second, private company which is not an associate company, subsidiary company of any other company. Okay, so first was a startup company. They enjoy this relaxation for 10 years. There is no limit on the acceptance of deposit. Second, private company which is not an associate company or subsidiary company of any other company. Okay, means a private company which is alone, there is no such association. Okay, third, private company whose borrowings from banks, financial institution, any other body corporate is within the limit. Is within the limit. If the borrowings made by the private company is within the limit. What is the limit? Limit is twice the paid up share capital or 50 crore rupees, whichever is less. Okay, twice the paid up share capital or 50 crore, whichever is less. I hope this is clear to everybody. Yes? Okay, next is, yes, a private company which has not made default in the repayment of deposits. Okay, under section 73, and such default should not subsist at the time of acceptance of deposits. So 4 companies, no limit on acceptance of amount as deposit. Okay, yes, next we go to the rate of interest. Tell me, is company going to pay interest on deposits? Yes. What is the rate of interest which company can pay? Come on, if Reliance Industries starts giving you interest on deposits that is at the rate 20% per annum, what will people do? People will take out all the money from all the banks and put all the money in the deposits, and all the money will be given to the companies. Therefore, here there is a rule that the rate of interest given by the companies on deposits that cannot exceed the rate of interest as notified by RBI for NBFC. Okay, so RBI has already prescribed the rate of interest for acceptance of deposits by NBFC. Is this clear to everybody? Means the RBI has allowed NBFC, non-banking financial companies, to accept deposits and give some amount of rate of interest. So whatever the rate of interest which is notified by RBI for NBFC, the same rate of interest shall be the limit for the other companies. for acceptance of deposit. So company cannot pay interest more than which is allowed to NBFC by RBI. Same rule is applicable for brokerage also. Now, who can be the broker? People invest money in the company through brokers, intermediaries. So, who shall be the broker? And how much brokerage he should charge? So, again, the person who is authorized in writing by the company to seek deposits, that is to solicit deposits on the behalf of company. Okay, the person who has been authorized by the company. Company has appointed someone in writing that you can accept deposits on behalf of company. Such person is said to be the broker. Okay, such person shall be said to be the broker. And the amount of brokerage which he can charge is again the amount which shall not exceed the amount which is prescribed by RBI for NBFC. Okay, so there is a limit for both. Okay, now next part is again rule 3, right to alter the terms and conditions. Tell me one thing, company is required to issue what? Circular for acceptance of deposit or prospectus, correct? Now company and prospectus and circular contains all the terms and conditions, right? Now suppose if company has already issued circular, company has already issued a prospectus, okay, having all the terms and conditions in it, and company has also accepted deposits. Now earlier in the prospectus it was mentioned that company will be paying interest of 8% per annum. Company will paying what? How much interest? 8% on deposits. Now after accepting deposits, obviously after issuance of circular prospectus, after acceptance of deposits, now what company is doing? Now company wants to alter the terms. Can company now alter the terms? Answer is no. Now company cannot alter. Company shall not reserve itself either directly or indirectly a right to alter, okay, the alteration which is disadvantage to the depositor, any terms and conditions of the deposit trust deed, right? All these things, nothing can be altered after the circular in the form of advertisement is issued and deposits are accepted. Friends, are you getting my point? What I'm saying? Once it is accepted, once it is issued, now no changes. Okay, what if originally? Yes, I'm coming to that part only, dear. Listen to me. What if originally it was saying that company will pay interest of 8%. But now company wants to alter the terms and now company is saying that we want to pay 9%. Can company alter it? Yes, because the interpretation says here is no alteration which is disadvantage to the depositor. But can we make the alteration which is an advantage to the depositor? Yes. Easy, everybody? Simple? Yes. And in the deposits also, company have to obtain the credit ratings. Yes. आएगा बेटा आगे टॉपिक है उसका. Okay, now what is this credit rating? You all know that. Come on, you tell me one thing. When the movies are released, how do you determine whether you want to watch this movie or not? On the basis of ratings, right? So if a movie gets 2-star rating, will you go and watch? You're not going to waste your time and money. If the rating is 3, will you go? 4 you may go, right? 4.5 and above, everything is good, so you may go in that case. So that is the point here also. If people wants to make investment in the company in the form of deposits, how will people know whether this company is having track record which is benefit for the investors or not? So for that purpose, every company which accepts deposits, every eligible company shall obtain at least once in a year a credit rating for deposits accepted by it, and the copy of rating shall be sent to ROC. You know, companies have to file returns on deposit. See, company, if throughout the year company has accepted deposits, So after the end of financial year, company have to file the returns of deposit. That is in form DPT 3. However, there is a separate topic for this also which will come later. So in the form DPT 3, company will file the returns. So in the returns, company have to mention the credit rating which company has received from the credit rating agencies. Yes. So company have to obtain at least once in a year credit rating for deposits, and the copy of it shall be sent to the ROC, okay, along with the returns in form DPT 3. Okay, clear everybody? So considering those ratings, people will make their investment decisions. Now next is, this is the form of advertisement and all. Yes. Now we continue with 73. How to repay the deposit? Very simple. Company have to repay every deposit with interest in accordance with the terms and conditions of the agreement. You understood everybody? In accordance with the terms and conditions. Okay, what if company fails to repay the deposit? Where will you go to complain? NCLT, very simple. So the depositor concerned may apply to tribunal for an order directing the company to pay the sum due or loss damage incurred by him as a result of non-payment. Clear? Okay. Now, yes, can you see this DRR account we spoke about? Company have to open a separate bank account in scheduled bank called as DRR account, right? Now friends, company is transferring how much amount in DRR? 20% of the deposit matured in the following year, right? So company should utilize that money only and only for the purpose of repayment of deposits and interest, and not for any other purpose. Okay, so DRR account shall not be used by the company for any purpose other than repayment of deposits. Easy? So with this, we are done with the first main section, that is 73. The main section is 73 and 76. 74 and 75 is also there, but 74 is talking about acceptance of deposit before commencement of Companies Act 2013, and 75 is talking about penalty. Okay, otherwise main is 73 and 76. Easy everybody? Yes? Can we do one more section? Then we can go for break. Okay. Correct. So that is for the delay which company have to pay. But plus there is a penalty for non-compliance which is imposed on the company. Plus company have to repay the deposits with interest, it is penal interest for the delayed period, that is 18%. You will see that part also in the module. Yes, come on. 74. Everybody please concentrate. 74. See in 74, it is about repayment of deposits accepted before commencement of the act. Before commencement of the act means before Companies Act 2013 came, if company has accepted deposit, suppose if company is having some X amount in the form of deposit, and now Companies Act 2013 is effective, all these rules are getting effective. So how to treat that money in the form of deposit which company has already accepted before these rules came? Correct? So how to treat that money? Answer is, as soon as the new act is effective, what company is required to do? So friends, company have to file a statement. Company have to file a statement of all the deposits accepted by the company. Okay? and file with whom? File with ROC. So company have to file this statement within a period of 3 months from the commencement of this new act. Okay, so company within 3 months will file a statement containing what details of all the deposits accepted by the company and sums which are unpaid with interest. Okay, so prepare a statement, file the statement within 3 months with ROC. So filing must be done within 3 months. And now new act is effective. So what about the deposits which company accepted before the act came? So obviously do company have to repay this money? Obviously yes. So company have to prepare a statement within 3 months and company have to make the repayment within 3 years from the effective date or expiry of the, that is basically maturity date of deposits. Okay, whichever is earlier. Is this clear to everybody? Yes. Okay, next part. Now suppose if company says that we had accepted deposits before the act came, and now you are saying that we need to make the repayment within 3 years from the commencement date or maturity of deposit date, right? But company says that we need some more time. We want to make some arrangements for payments. So can NCLT allow more time? Yes. Company may apply to NCLT and NCLT may provide the further time as considered reasonable to the company to repay the deposits. Is this clear to everybody? NCLT may allow you further time after considering the financial condition of the company. Okay, so now obviously now company have to make the payment within the specified time, that is within the promised time or within the further allowed time by the NCLT. Company have to make the repayment now. Okay, now if company fails, always interest is for the delayed period. If company fails to repay the deposit, part of deposit or interest thereon within the specified time or further time as allowed by tribunal, as I told you. So if company fails to do this, in such case, company, in addition to the payment of deposit and interest, means company have to pay the deposit and interest anyway, but company shall be punishable with fine not less than 1 crore rupees, which may extend to 10 crore rupees. Fine on the company is 1 crore to 10 crore. This is on the company, okay? But every officer of company who is in default shall be imprisonment, which may extend to 7 years, or with a fine minimum 25 lakh rupees, which may extend to 2 crore rupees, or with both. This is for officer in default. Easy. So this was your section number 74. And then you can see here 75. 75 is just talking about the penalty. So you can read that, no concept in that. Okay. And then we are here starting with the rules of deposit now. Okay. What does this rule say? So you know very well, company, if accepting deposits, company have to create security. Company have to create charge on its assets by the way of charge on its asset. Okay, but the charge should be on which type of asset? Tangible asset and not intangible asset. And obviously the value of that property shall not be less than the amount which is companies to be repaid, or the insurance amount. Okay, so here you can see who will determine the value of property? Registered valuer. Okay, and so on. And next rule is acceptance of deposits from public by certain companies. That is section number 76. Why it's written there acceptance of deposits from public by certain companies? Why certain companies? Because only eligible public company can accept deposits from public, no? Therefore, it is certain companies. Okay. So can I say we are done with 73, 74, 75, which was penalty. And now the last one is 76 and some connected rules. Okay. So we can do this after break. Okay. Last one. So see you after a small break. Thank you. डिविडेंड में होता है वो. But yes, deposits का भी पैसा. If deposits are matured, there is no one to claim. Company will keep it in a separate account for 7 years. After that, IEPF. Sub IEPF is for so many things. It's not only for dividend. chalo, let's continue deposits. So acha, so they will decide our timing, they are not chief guest. Chalo, 76. So friends, as you know, 76 we talk about acceptance of deposits from public, right? So here, who will accept deposits from public? Obviously, eligible company, right? Eligible company can accept deposits from public. Now again, they have given meaning of eligible company. So eligible company is a company whose net worth is not less than 100 CR or more, or turnover is 500 CR or more. So eligible company can accept deposits from person other than members. Obviously, other than members means any person, including public, subject to compliance, right? Compliance requirement, they have to satisfy certain conditions, and then they can accept deposits from public. Okay, so what the compliance requirement? So see here, they are saying that they need to obtain credit rating from a recognized credit rating agency. Okay, they need to inform public about the rating given to them at the time of invitation of deposits from public. Okay, then you need to create charge on its asset. Okay, then next is punishment for contravention of 73 or 76. It is not 73 to 76, it is 73 or 76. So this part is just talking about the penalty. So you can just read that. Next is trustee. You know, there is one person who is appointed by the company called as deposit trustee. Deposit trustee. Who is this deposit trustee? Deposit trustee is a person appointed by the company to protect the interest of depositors, to protect the interest of investors, right? Now friends, if you come to know that there is one person who is appointed by the company to protect your interest, so obviously your trust in that company will be increasing day by day, because there is someone to take care of your interest. So that person who is going to take care of your interest is called as deposit trustee. So there were points related to deposit trustee, right? If you remember. So first point was company can appoint one or more deposit trustee. First point. Company can appoint one or more deposit trustee. Second point. When you appoint this person as a deposit trustee, you know, you need to take his consent first. You need to take his consent that he agrees to act as a deposit trustee for so and so company, his details and everything. And that consent should be mentioned in the circular, prospectus, everything. Okay, so that is also the point. Point number 3. First point, one or more deposit trustee shall be appointed. Second, okay, when he will be appointed? Deposit trustee shall be appointed at which point of time? Before issuance of circular, advertisement, prospectus. Second point. Third point, you need to take his consent to act as a trustee, and this consent shall be the part of prospectus, circular, so on. Clear everybody? Yes. Can you see this written consent shall be obtained? Okay, before his appointment, statement shall appear in the circular also. Okay, all the details shall be there. Now you know what? What shall be his tenure? What shall be the tenure of deposit trustee? His tenure shall be as mentioned in the deposit trust deed. You know, there is an agreement between company and this trustee. There is an agreement called as deposit trust deed. Agreement called as deposit trust deed, which is in form DPT 2, which is in form DPT 2. Okay, so this is a trust deed. All terms and conditions of his appointment is mentioned in the trust deed. When will company enter into this trust deed? This agreement between company and trustee. When will company enter into this trust deed? So answer is at least 7 days before the issuance of circular. 7 days before the issuance of circular, this agreement must be done between the company and trustee. Okay. The next point, he must be an independent person. What is this independent person? Means he has to be unbiased, right? Now, when can we say that he can be act as independent person? So there is eligibility for his appointment. Here is the eligibility, which is something similar to what you have done in your independent director. But in independent director, there were many more points than this. Okay, so here you can see person who cannot be appointed as deposit trustee. So here you can write as disqualifications of trustee. Disqualifications of trustee, here are the points. Who cannot be a trustee? Because see, if that person is having some connection with the company, he is going to be biased. So therefore, no person shall be appointed as a trustee for depositors if he is a director of company, if he is a KMP of company, any other officer, employee of the company, holding company, subsidiary company, associate company, or he himself is a depositor, then he is not eligible. If he has indebted to the company, subsidiary company, holding company, associate company, subsidiary company of such holding company, then also he is not eligible. Then if he is having some material relationship, pecuniary relationship, that means what? Monetary relationship with the company. If he has entered into any guarantee agreement, then also. And if he is also relative of any of the persons mentioned in clause A. What is clause A? This one. If he is relative of any of them, then also he is not eligible to become deposit trustee. So you can write the disqualifications of deposit trustee. Okay, fine. Now here there are few duties of deposit trustee. All the points talks about only one thing. What? Protect the interests of depositors. And there is one more point. You know what company creates charge? I told you, right? So rule 8 is also saying that if company has created charge on its property, the value of property must be more than or equal to the repayment amount of deposits along with interest, correct? But what if the value of property goes down? So it is his duty to inform NCLT. Understood? Obviously first he will be informing the company, and company have to create the additional charge. But if company does not take such action, it is his duty to protect the interests of depositors by informing NCLT. Okay, fine? Yes. Now friends, you know what? There is a separate meeting of depositors in the company. Only depositors meeting, yes. Come on, tell me, is this a general meeting? Is this a board meeting? This is a class meeting, because it's a meeting of a particular class of security holders. Come on, when will they conduct a separate meeting of depositors? That is, trustee may call this type of meeting of depositors suo motu. Okay, trustee may call such meeting. Okay, when will trustee call such meeting? Whenever trustee receives a request in writing signed by at least 1/10 of the total depositors in value. Okay, 1/10 of the total depositors in value means it is not 1/10 of the total number of depositors. Value wise, you have to see 1/10. Okay, value wise, if this many depositors make request to the trustee, in that case trustee will call the depositors meeting. Okay, or whenever there is happening of any event which constitutes a default, which was default made by the company in the opinion of trustee, which affects the interest of depositors. Whenever company does any such act due to which the interest of depositors are at stake, so that in that case trustee will call the meeting of depositors. Okay, so there are two circumstances. I hope this is clear. Then rule number 10 is talking about application for deposits. You know what? Company cannot accept deposits, cannot renew deposits, any deposits, okay, whether secured or unsecured, unless an application is made to the company. Unless an application is made to the company by intending depositor for acceptance of such deposit. You need to make an application to the company. You need to apply for deposits. Only then company can accept or renew deposits. And whenever you make that application, in that application you need to give a declaration. Who will give the declaration? The intending depositor, means the proposing depositor will have to make a declaration. What declaration he will make? He will make a declaration that the amount what he is being making in the form of deposit, the amount what he is investing, that money, the deposit is not being made out of any money borrowed by him from any other person. He will give this declaration that he is making investment of amount which is not borrowed by any other person. Okay, simple. Now, just like other securities, Rule 11 talks about nomination. So nomination point we already study in your chapter members and shareholders, section number 72. So just like shareholders, debenture holders appoint a nominee, here also you can appoint a nominee. Every depositors at any time may nominate any person to whom his deposit shall vest in the event of death. Is this clear to everybody? So you can apply for nomination under this rule. Easy. So if the deposit dies, the amount of matured deposit shall be given to the nominee. Fine. Now we know the shareholders who invest money in the company, they get share certificate. Debenture holder get debenture certificate. Similarly, what do these depositors get? These depositors get deposit receipt. What do they get? Deposit receipt. Okay. So you know, once the depositor makes investment in the company in the name of deposits, as soon as the payment is made, company have to issue a deposit receipt within a period of 21 days. How much time? 21 days. Can you see this? Every company shall, on acceptance of deposits, furnish to the depositor or his agent a receipt for the amount within a period of 21 days from the date of receipt of money, realization of check, or date of renewal. I hope this is clear. So he gets a receipt within 21 days. Easy. That receipt must be signed by the officer of company, okay, who is authorized by board. Name of depositor, address of depositor, amount of deposit, rate of interest payable, everything is mentioned on the receipt. Okay, clear? Now friends, you know something called as DRR, rule 13. Yes, creation of DRR. Already we have done this earlier. Every company, yes, and every eligible company under section 73 and every eligible company have to, on or before 30th of April every year, have to open a separate bank account in a scheduled bank, and that account is called as DRR account, and company have to transfer at least 20% of the deposits getting matured in the following financial year. This much amount should be transferred in a DRR account, and the amount which is transferred in DRR account, that amount shall not be utilized for any purpose other than repayment of deposits. Easy. Now, same ही था. Yes. Now register of deposits, like company maintains register of members and all, similarly register of deposits. Rule 14. Every company which accept deposits will keep at registered office one or more registers, record of deposits accepted by the company or renewed by the company. Okay, so here is the list of records which company will keep in the register. You can see name, address, pen of depositor, details of guardian if depositor is a minor, then details of the nominee if nomination is done. Obviously company issues deposit receipt, so deposit receipt number, date and amount of each deposit, duration of deposit, rate of interest, due date of payment, payment of interest mandate dates, right? All the other details. Now friends, when company is maintaining this type of register, when will company do entries in the register? Company will make the entries in the register within a period of 7 days from the date of issuance of receipt of deposits. And when will company issue receipt? 21 days from the date of payment. So company will, and it is within 21 days, not after 21 days. Means company can issue receipts after 10 days also. So from the day when company issue receipt, from that day, within 7 days, company have to make the entry in the register. Okay, yes, and that entry which is made in this register shall be authenticated by director or CS or by any other officer authorized by board for this purpose. Okay, company shall preserve this register for a period of not less than 8 years from the financial year in which last entry is made in the register. For example, if the last entry is made today, no, yes, after the end of the current financial year, 8 years. Okay, easy. So this was about the register. Now rule 15 is talking about premature repayment of deposits. Can you ask for your money on premature basis? Yes. So on application, can you see that on the request of the depositor, company may repay you your money before maturity date. Correct? But there are conditions. Company can repay the deposits before maturity? Yes. But company cannot repay the maturity, cannot repay the deposit before maturity, that is earlier than 6 months. Because 6 months is the minimum duration of deposit. So not earlier than that. Okay, can you see that? Before expiry of the period for which the deposit was accepted. Okay, and can you see this after expiry of 6 months? That is minimum you need to wait for 6 months. Is this clear to everybody? So this was the first condition, not earlier than 6 months, as it is minimum period. And the interest what you will get now, that is going to be agreed rate interest minus 1%. If originally company had agreed to pay you 8%, now company will pay you 7%. Okay, so interest will be reduced by 1% from the rate which company would have been paid if the deposits were originally accepted for the original period. Is this clear? Come on, what is the thing here? Can you accept, can you ask for your money on premature basis? Yes. So company can do that, but not earlier than 6 months, and rate of interest shall be reduced by 1%. Easy. But you know what? These two conditions which we spoke just now about, there are exceptions to this. Yes, beta, we're coming to that point only. There are two exceptions to this point. Means the above rules are not applicable in two cases. First, if the deposits were originally accepted for less than 6 months. Can company accept deposits for less than 6 months? Yes. That is minimum 3 months. Are you getting it? So if original duration of deposit is, let's say 4 months, which is again less than 6 months. So original duration is 4 months. Now in that case, is it necessary for the company to keep the deposits for 6 months? No. Original period is 4 months. Promised duration is 4 months. So in such case, the above rule is not applicable. So first point, if the deposits were accepted for less than 6 months, first point, above rule is not applicable. Second, this is one thing, okay? First condition, which we spoke just now about. And second, if the depositor is a personnel of, yes, naval, military or air force, or they are family members, and now on an application, they want their money before time because emergency has been declared under Article 352 of Indian Constitution. If this is the case, again above rule is not applicable. Means rate of interest shall not be reduced by 1%, and also they can ask for the money before maturity, before 6 months. Is this clear, everyone? So very simple thing. Now the next part is returns of deposit to be filed with ROC. Yes, rule number 16. Now return of deposit, what is this? You know what, every company after the end of every financial year need to send the details of the deposits accepted during the year to ROC. That is called returns of deposit, and that is in form DPT 3. The returns of deposit is every company to which the rules apply have to file with ROC a return of deposit in form DPT 3. Okay, in DPT 3. Are you getting one point? Everybody understood this point? Now one more thing. After the end of financial year, for that particular financial year, how many deposits were accepted, to whom, what was the rate of interest, what was the duration, everything that is in the form of return you need to file with ROC. Okay, when to file this with ROC? That is on or before 30th of June. On or before 30th of June every year. You understood this? Means 30th of June is the last date to file a return. But in that, you are going to put the details as on 31st March of that year only. So that will contain the details of deposits up to 31st March. And you need to file that by 30th of June every year. Is this clear to everybody? And this shall be filed in form DPT 3. That's for every company, okay? And then disclosure is to be given in financial statement, rule 16A. You know, this financial statements, annual report, board report will contain all the details of activities done by the company throughout the year. So it shall contain the details of deposits also. Okay, here you can see every company other than private company shall disclose in the financial statements about the money received from the director and so on. Okay, then rule 17 talks about penal rate of interest. Yes, if company makes delay in the repayment, if company makes delay in the repayment of deposit, so obviously company will now have to make the repayment of deposits with interest, and penalty rate of interest is 18% per annum for the delayed period. Whether deposit is secured or unsecured, doesn't matter. Okay, easy. Now if any question arises, if any, rule 18 says that if there is any question arises related to applicability of the rules of deposits to a particular company, so who will decide the rule? Central government. If there is any question arises, let's say for example, what will happen if this thing happen? What rules are applicable in this case, that case? So who will give the clarification for that? Central government. Such question shall be decided by central government in consultation with RBI. Simple. Yes, and now these rules, yes, are applicable to eligible companies also. Simple. And here again there is a penalty for contravention. You know this penalty is for what? See, you saw there was a penalty for non-payment, right? If company fails to repay the deposit or its interest, is that in section 75 penalty which I told you to read, again that was failed to repay, correct? But there are so many things you need to follow in this chapter, like you need to file returns, you need to maintain registers and so many things, right? So if you don't do any of the things, if there is a contravention of any provision for which no penalty is given in the act, no separate penalty is given in the act, because we saw penalty only for non-payment. So if there is a contravention of any such provision for which the penalty is not given, so for that, this is the penalty. For that, penalty is company and officer in default shall be punishable with fine which may extend to 5,000 rupees. And if the default still continues, there will be further fine of 500 per day till the default continues. Okay. Now see friends, in this chapter you saw DPT forms. So DPT form number 1 was for format of prospectus and circular. DPT 2 was for trust deed format. DPT 3 was for returns. Now we have DPT 4. DPT 4 is for what? Do you remember about a statement which we need to make for the existing deposits? We have discussed this in section number 74. Do you remember company has accepted deposits before commencement of this act? So once this act comes effective, what company needs to do? Company have to prepare a statement and file the statement with ROC within 3 months. So that statement which company is going to prepare of the deposits which were accepted before commencement of the act, that statement shall be informed DPT 4. Okay, statement shall be informed DPT 4. Clear everybody? Okay, then this was rule 20, this is rule 21. Then here you can see disclosure in the board report. As I told you, all the details of deposits in this chapter is disclosed in the board report, forming the part of annual report. Deposit accept during the year, of how many are unpaid, unclaimed, right, where company has made default, so when default was made and all these things. Also you need to mention the details of deposits which are not in compliance with this chapter. Yes, company is required to make such disclosures in the board report, forming the part of annual report. Easy? And here specimen means here your chapter is over. From your ICSI module, completely done. Yeah, we referred notes only for the definition. Otherwise we did the chapter from the module only. Easy? किस में से? अभी? नहीं 18 definition, for definition you can refer that notes. Otherwise chapter is easy from module. So why students don't read module? I want to know that. If you ask anyone module, no, it is very difficult. It is not difficult. Problem is you are not reading it. It is very easy. If your concepts are clear, module will be very easy. Okay. So I hope now you will be comfortable to read this module. Don't skip anything. Every line is important. Okay. Done? Chalo. Good. So we are done with this. Debt instruments deposits part completely over. I also want all of you to give prelims. Don't miss prelims. See, if your prelims are starting from 7th of December, that is after Sanjivani. Sanjivani is getting over on 5th. So from 7th, your prelims will start. Okay. See, many students don't give prelims, and the reason is we are not prepared. If we have not done this, I have finished this subject only half, I don't know this, I don't know that. So if you're not prepared, you are only responsible for it. If you're not prepared for prelims, like 10-15 days down the line you have your main exam. So what magic you are going to do in that 15 days time? The magic which you couldn't do in few months, you will be doing that magic in those 15 days. So please be ready for prelims from now onwards. Okay, please do something. Beta, drafting lecture link has already posted in my previous video. The day when I told you, I have already posted the drafting lecture link in the comment section. In the second lecture of my Sanjivani this season. You can please see that comment. Okay, and second, debentures part, beta, debentures part is very easy. Therefore, we are not putting the time in this. But as you can see the previous seasons of Sanjivani, you will see that debenture part over there. Okay. Yes, I will be taking amalgamation chapter also. Don't worry at all. I will be doing amalgamation merger chapter. I am also going to do share capital chapter. Tomorrow's lecture, we are going to start with share capital only. Okay, and we will finish share capital tomorrow. 100% from module. Okay. So now we are done with how many chapters? Let's say we are done with debt instruments. Then we will be doing this compromise in arrangement. Then we have done with general meetings. We have done with directors. We have done with board meetings. We have done with KMP. Right? Yes, CSR is not there now. This is also not there. Annual report hai. In fact, few topics of CSR is a part of annual report now. Yes, that is very easy. We will be doing share capital also. So how many chapters we are going to cover this time in Sanjeevani? 1, 2, 3, 4, 5, 6, 7. 7 chapters. And all 7 are very big chapters, important chapters. Okay, so what's next? But that cannot be done in 1 hour time. So आधा करके छोड़ दूँ. I will do one thing for all of you. If you want MOA and AOA, what I will do, once the Sanjeevani, this timetable is already scheduled for the entire Sanjeevani. So what I will be doing for MOA AOA, I will record that MOA AOA revision in studio and we will post that on this YouTube. Okay? Will not disturb the timetable which is already planned. So, but I assure you we will be doing that. I will record that. Okay? MOA AOA chapter ka revision. Yes, yes. Part B is almost done. Annual report is simple thing. CSR is not there now. Now only board composition is left. Yes. See, I want to discuss today questions also. So we will take one small chapter and then we will discuss few questions because yesterday we couldn't discuss question therefore. So which chapter to be taken? Dormant company? Then which one? Small chapter. फीचर्स ऑफ कंपनी करवाएगा रिविजन में. कुछ अच्छा ले यार. वो मैं करा दूंगा. वो तो पहले के सारे संजीवनी में भी है. हाँ, ऑलवेज आई टेक दैट चैप्टर. सारे सीजन में है. आई वॉन्ट टू डिस्कस क्वेश्चंस टुडे. बुक बुक बुक. बस बस. चलो. So we are going with the questions. Okay, let's see what is आज का सवाल. What is आज का सवाल? आज का सवाल क्या है? अभी लॉ टीचर ऑन ड्यूटी चल रहा है. Okay, chalo. So, so friends, we are starting with the question answers. Please concentrate. Case study question, past exam question. Are you ready? So question is coming from the chapter which we have not revised, so that indirectly we can cover that chapter also. So chapter is members and shareholders. This question was asked in 2012, and even after that, recently also it was asked. They have just changed the name. So what is the question? It is very good question for practice. Mohan applied for 4,000 shares in a company. Okay, concentrate. Mohan applied for 4,000 shares in the company, but no allotment was made to him. It was not allotted to him, right? But subsequently, 4,000 shares were transferred to him without his request. So earlier already no allotment was made, but later on, okay, subsequently shares were transferred to him without his request, and his name was entered in the ROM, Register of Members. Mohan knew it, but he took no step for rectification of ROM. Subsequently, the company went into liquidation and he was held liable as a contributory. So now Mohan wants to apply to court for rectification of ROM. Can he do so? Explain. Come on, now can he do so? He's saying that no, I am not a member. Why I am held liable? I never got shares. All these things he's saying. Come on, what do you think? Do you know, here we are talking about one of the circumstances of how to become a member of company. So how to become member of company, we have done so many things. So one of the point was member by estoppel. See here, obviously shares were not allotted to him, correct? But later on, his name was entered in ROM, right? Without informing him, and he was aware that his name is entered, shares are allotted to him without his request. His name is entered in ROM by mistake. So now he was taking benefit for a certain period of time. Maybe he is accepting dividend for a certain period of time. So that time, can I say he was not a member, but he was acting like a member? Means whenever he came to know about this, he didn't raise any objection. So when he came to know about this, he should have raised his objection and he should have applied to the company for rectification of ROM. There is a concept of rectification of ROM in chapter members and shareholders. He can request the company for rectification of ROM. If company does not do that, he can appeal to NCLT or competent court outside India. Correct? He can request that, and then his name should have been removed, because actually he has not applied for any such shares. But he did not do that. He raised no objection. So now he will be deemed to be the member of company. He shall become the member of such company by estoppel, that is by his representation, by his behavior. So now tell me, is he liable for the liability which has arisen when company went into winding up? Answer is yes. Because you were not a member, you were acting like a member. And now when liability arises, you are saying, no, I am not a member, no liability, no liability. So when you take the benefit, you also have to take up the liability. So now you are considered as member by estoppel. Clear, everybody? Nice question. So here you will write what all things. First, member by estoppel. Also you are going to explain, after member by estoppel, you are also going to explain rectification of ROM. Both the things you will write here in provisions, then facts, and then conclusion. So conclusion will be, obviously Mohan now cannot apply for rectification of ROM. His request shall be refused by the court, and he shall be held liable as a contributory when company is in liquidation. Okay, so I hope this is clear to everybody. Yes? Come on, next question from the same chapter, members and shareholders. Online, everyone, are you ready? Yes, you know what? See, solving questions are equally important. As you attend lectures, you understand the concepts. But this is like test yourself. So members and shareholders, come on, what is the next question? Next question is, A to Z, again exam question. This question was asked in June 2017 paper for 4 marks. Okay, so question is A to Z Management Services Limited is a listed company quoted at Bombay Stock Exchange Limited. The company closed its register of debenture holders in June and August. Company closed its register in the month of June and August for 12 and 21 days respectively. June and August for 12 and 21 days respectively. The CFO of the company has informed the secretary of the company, that is CS of the company, to consider the closing of register in December for another 15 days. You understood what I'm saying? They want to close for further 15 days for some strategic reasons. So referring to the provisions of Companies Act 2013, examine the validity of the above action of the company. What do you think? Come on. So can company close its registers? Company can, is it compulsory for company to close the register? No. But if company close the registers voluntarily, company have to do the compliance requirement. Company have to follow this compliance requirement. What is the compliance requirement? Company can close its register for maximum 45 days aggregate in each financial year, and company can close its registers for maximum 30 days at one time. Correct? However, company is required to give 7 days advance notice or lesser period as prescribed by SEBI. Are you getting the point? So those all things you need to write here. Because here you can see company is closing the register for how much time? First 12 days. Then 21 days. So it is 33 days. Plus more 15 days. So that is going to anyway that is anyway going to exceed 45 days. Understood? So that is the rule in one financial year. Easy, na? Yes, he cannot close for more than 45 days. That's what I told. Come on, answer this question from deposits. Issue of unsecured debentures by a company. Company is issuing what type of debenture? Unsecured debentures by a company to another company, where the debentures have an option for compulsory conversion into equity shares within 7 years. Cannot be termed as deposits. Comment. Come on. Issue of unsecured debentures by a company to another company, where debentures have an option to convert for compulsory conversion into equity shares within 7 years, cannot be termed as deposits. Comment. Come on. Company has received money by issue of what type of debenture? Unsecured debenture. But it is compulsory convertible into equity shares. So whatever amount company has received, is that a debenture? Is that a deposit? The amount received by the company, such receipt of fund, is treated as a deposit or it is not treated as a deposit? Answer this. Come on, let us remember the definition. Do you remember the point number 4 which was talking about debenture? So company has received funds by issuing secured debentures or compulsory convertible. Compulsory conversion must take place within 10 years. Then it is not a deposit. It is secured or compulsory conversion. So if it is unsecured but compulsory conversion, then the amount which is raised is deposit or it is not a deposit? It is not a deposit. I am talking about unsecured. See, if it is secured or compulsory convertible. So if it is secured, it is the amount what company has raised is not a deposit. Correct? Suppose if it is not secured, but it is compulsory convertible. If it is not secured, if it is unsecured, but it is compulsory convertible, then come on, and conversion shall take place within a period of 10 years. So here they are doing conversion within 7 years. So amount which is raised by the company is deposit or not a deposit? Not a deposit. That was loan. This is debenture. Not a deposit. Within 10 years is allowed, na? तो deposit है. Everybody understood? Beta, it is not a deposit because it is compulsory conversion, compulsory convertible debenture. Remember that definition point. It is either secured or it is compulsory convertible. So here you can see compulsory convertible. Okay. Okay, I'll repeat it again. See, we did that point in the definition. If company has raised funds by issue of secured debenture, so amount what company has received by secured debenture is not a deposit if conditions are getting satisfied. What were the conditions? Debentures are secured, charges created, security is created on the tangible property, value of property must be more than or equal to the repayment amount, the value shall be determined by the registered valuer. This was the point. So in all the 4 points we are talking about secured debenture. Suppose if it is not secured, but it is compulsory convertible debenture. So money raised by the company by issue of compulsory convertible debenture is a deposit, not a deposit. It not a deposit. If the condition, if the conversion takes place within 10 years. So here you can see conversion is taking place within 7 years. Therefore, it is not a deposit. Condition is getting satisfied. Therefore, it is not a deposit. Because that list which we were doing of 22 points, that list was for exclusion. Correct? Everybody understood? Yes. Indian Idol. Relax. Okay. All questions are very easy. You will answer it like anything. What is this? See, the board of directors of Greenfield Limited decides to accept deposits from public at a compound interest rate of 12% per annum. Okay, so board of directors of the company decides to accept deposits from public at compound interest rate of 12% per annum. Examining the provisions of Companies Act 2013, advise whether the board can go ahead with the proposal. Come on, tell me, was there any rule about the limit on rate of interest? But was any number given? No, the law just says that the rate of interest which company can pay on deposits in the form of return shall not exceed the rate which is prescribed by RBI for NBFCs. So if the 12% is one of the limits, then there is no problem. Okay, this was for 4 marks. Easy na? Chalo. Nice question is coming. Superb question is coming. Are you ready? This question was asked in December 23 paper for 3 marks. Okay? Please listen carefully. The board of directors of ABC Limited. Okay? I'll just write it down for you. Board of directors of ABC Limited is planning to invite deposits from public. Okay, they want to invite deposits from public. Okay, for the purpose of meeting its short-term requirement of rupees 20 CR. They want to raise how much? 20 CR. In the scheduled meeting to be held on 1st of October 2023. Deposits will be repayable within 4 months. Means they want to raise money for 4 months from the date of such deposit. The paid up share capital of the company is 225 crores. Okay, and the paid up share capital is 225 crores and free reserves is 375 crores. 375 crores respectively. Okay, now the CS of company ABC Limited, CS of the company opposed the above proposal of board of directors. Okay, CS opposed. CS opposed the proposal of board of directors with the contention that company cannot accept deposits which is repayable earlier than 6 months from the date of such deposits. So advise the board of director of ABC Limited as per the provision of Companies Act 2013. What do you think? Come on everybody. Here company wants to accept deposits for 4 months. So can company accept deposits for 4 months? That is less than 6 months because minimum duration for deposit is 6 months. So here company is accepting deposits for less than 6 months. Is that allowed? Yes, but there were two conditions. First condition is it should be not less than 3 months, not earlier than 3 months. And second condition is there is a maximum limit of 10%. 10% of security premium, free reserves and paid up share capital. But here security premium is not given. Means we will take only this two. Right? Yes. So friends, they can accept deposit, but we need to check the limit. So what is the limit? Please check. 10% of paid up share capital plus free reserves. That is 225 crores plus 375 crores. It is 600 crores. So 600 crores ka 10% is 60 crores. So what is the limit? 60 crores. They want to raise how much? 20 crores. Is this within the limit? It is within the limit. So can they raise this money as deposit for less than 6 months? Yes. So therefore the contention of CS is not valid. ये हमारा स्टूडेंट नहीं था. He is opposing side. He notes हमारा स्टूडेंट के पास notes होता है. जोरदार हमारे स्टूडेंट्स मॉड्यूल से पढ़ते हैं. No, our students read from module, directly from module. So they know, all our students watch Sanjivani series. So they know the rules very accurately. Okay, nice question now. But this will give you only 3 marks. But 3 marks is okay. 3 marks is not less. Good. That was a smaller one. This is a big question for 3 marks. See, if you see this question, it will look like a very big paragraph. So when this is exam question, December 23. आता है मतलब क्या? मैं घर से लाया हूँ. मैं बोल रहा हूँ ना आपको attempt के साथ. This question is coming from December 23 paper, 3 marks. Understood? Yes. Nice question. Everyone, YouTube, online, समझ रहे हैं? Yes. Okay, one of my students is saying you can please like, share, comment. Okay. Thank you. Share also. Okay, share also. Chalo. One more question. One more nice question is coming. Everyone ready? Solid question is coming. Solid question. You all will like it. Same chapter. Deposits. Question is coming from December 2022 question paper. It was asked for 5 marks. Lottery. Okay? Ready? Before this, I want to show you one question. We will discuss this question only. But in 2012 syllabus, see, first it was 2012 syllabus, which was applicable for 5 years. Then it was 2017 syllabus. Now it is 2022 syllabus. I am talking about 2012 syllabus. Yes, which last till 2017 attempt, right? You know what? In that question paper, one question was asked from this chapter, and that question was asked for 8 marks. Now you don't get questions for 8 marks. Question सुन ले, हवा टाइट हो जाएगा. Question is, define the term deposit and list out the receipts of money which are not considered as deposit. 8 marks. Buffet of marks and buffet of your points to frame this. So in this you need to write all the points. List out the things which are not considered as deposit. This is not that paper. Write any 4, write any 5. 8, they are giving you 8. Time nahi hai, that is your problem, no? So therefore answer is no. You have to write everything. Finish. No settlement. Now they don't ask for 8 marks. Now see, we are coming back to our question now. So question is coming from December 2022 paper, 5 marks. Question is, AB Limited whose net worth is of 51 crores. Okay, should I write it here so that you can get connected? AB Limited net worth is 51 crores. Annual turnover is 400 crores as per the latest audited financial statements. So this company now intends to accept deposits from general public. Okay, this company wants to accept deposits from general public. Okay, fine. Now see, understand, from general public. In this scenario, answer the following questions as per the provision of Companies Act 2013. First question. How much amount of deposit could be accepted by AB Limited from general public? Why? Which company can accept money from general public? Eligible public company? Yes or no? Only eligible public company. Please understand. So tell me, is this company a eligible public company? Which company is called as eligible public company? Net worth is 100 CR or more, or turnover is 500 CR or more. Your net worth is only 51, so it is not 100 CR or more. Turnover is only 400, so it is not 500 CR or more. Therefore, this company is not an eligible company. Therefore, this company cannot accept deposits from general public. This was the answer to the first sub question. Okay, which will give you 1 mark. In this, you need to write the meaning of eligible company, by the way, and then conclusions. Come on, second one. If AB Limited is an eligible company, for accepting deposits and could not pass SR of its member, could not pass special resolution of its member, what other options are available to the company to borrow funds beyond the limit prescribed under section 180 of Companies Act 2013? See, today we have revised this. When we started the chapter from the module, where this was the first para which we saw in the module. Come on. Do you know what is 180? Restrictions on the power of board. So here they are saying that if this company is an eligible company, for example, so they want to accept deposits and SR is not passed. by the members. So what other options are available to them to borrow the funds, obviously in the form of deposits, borrow the funds, okay, beyond the limit prescribed under section 180 of Companies Act 2013. Anyone? Come on, they want to accept money beyond the limit. Do you remember 180? Today only I told you this. Yes, that is third point. If company wants to make the borrowing beyond the limit. So what is 180? Restrictions on the power of board. So in those restrictions, what we have done, that is part of directors, right? Board composition chapter. So you know what? The 5 points which I wrote in class in notes. No, I'm talking about 180, section 180. Okay, so in that we did, if company wants to do any of this activity, company is required to pass SR. Means company needs to take the approval of its members. That was compulsory because company wants to make the borrowing beyond the limit. So here in deposits model we saw, if company wants to accept deposits within the limit of 180, then company can do that by passing ordinary resolution. But if company wants to do that beyond the limit, company is required to pass special resolution. So here they want to do beyond the limit and SR is not getting passed. What other options are available? No other options are available. Simple. Okay. If it is within the limit, OR. Beyond the limit, SR. Simple. Easy. 1 mark. Third sub question. As an eligible company for accepting deposits, what are the forms required to be filed by the company for acceptance of deposits? DPT 1. Do you know that before we issue prospectus, we need to file it with ROC? When? You need to, what? 7 days was for making deposit trust deed. 7 days before the issuance of prospectus and circular. Here we are talking about something else. Here we are saying that as an eligible company, for what forms company is required to file for acceptance of deposit? What all forms company files? Come on. DPT 1 is prospectus, circular format, advertisement format. So before issuance, you need to file it with ROC. 30 days before its issuance. That is one. DPT 1 we will file with ROC. Come on. What's next? So if we are passing SR, in case we are raising money beyond the limit, otherwise no. So if SR is passed, we will also file MGT 14. Come on, what else? Then DPT 3. DPT 3 was returns of deposits accepted during the financial year. So that also we are going to file, right? If we are the deposit trustee, that is a deed, that is DPT 2, right? So 1, 2, 3. And if we have accepted deposits before commencement, then DPT 4 also will come. That is a statement. Okay, so all the 4. Along with MGT 14. Hey, one more thing. When we are accepting deposits, we need to create security. 1 minute. So we need to create charge. Once we create charge, we need to register the charge. For registration of charge, section 77, we need to apply to ROC. In which form? CHG 1. Why not 9? 9 is for debentures. 1 is for registration of charge. So here we are going to talk about CHG 1. Easy. Nice question. 1 mark. Fine. Sub question number 4. Online also all are enjoying, I guess. Everyone. They are so active in chat box. What padhai karo? You ate vada pav in break, I know. Chalo. 4th sub question. How much quantum of money should be deposited in a separate account for deposits maturing in each year? At least 20% of the deposits getting matured in the following financial year should be deposited in a separate account, bank account, to be opened in scheduled bank. Correct? That is called as DRR account, deposits, repayment, reserve, and that amount should not be utilized for any purpose other than repayment of deposit. 1 mark. Now, uh, sub question number 5. Is there any time limit for issuance of deposit receipts for money accepted? What is the time limit? 21 days from what? From receipt of payment or realization of check. You can say that. And you can also write that once the deposit receipt is issued, that it is signed by whom, then it contains what all things. Do you remember? The name, duration, all those things were there. And also you can write once the deposit receipt is issued, company makes the entry in the register within 7 days from the day the receipt was issued. Correct? Done. So these 5 sub questions give you 5 marks. Interesting. But don't forget to write the contents of register. That is if CG notifies any company to be exempted. Central government notifies in official gazette that so and so companies are not required to follow these rules. So if notified, those companies are also exempted. One nice question is coming. Super duper hit question is coming. I know. See in that chapter dividend, everyone, please do that rule 3 concept very nicely. Huh? Rule 3. You know when do we talk about rule 3 in dividend chapter? When do we talk about rule 3 in dividend chapter? Rule 3 of company's acceptance, declaration and payment of dividend rules. Rule 3. We talk about rule 3 when company intends to declare dividend out of the past profits. It is out of free reserves. There are 4 rules, 4 points in rule 3. So if company wants to declare dividend out of the free reserves, out of the past profits, accumulated profits, so company need to comply with the certain requirements. So please do rule 3 very nicely. And rule 3 is applicable only and only when company wants to give money from past profits. Otherwise, no. Okay, okay, okay. ठीक है ठीक है. Easy था. Come on, one question. See, there was a chairman of meeting. There was a chairman of general meeting, and he was also the member of company. He is chairman also and he is the member also. Chairman counted the votes. He counted the votes. 6 votes were in favor and 7 votes were against the resolution. Okay, this was the counting. Now tell me, this person can vote as what? Chairman or as a member? He can vote as both. So what he did, he casted his vote as a member. So he casted his vote as a member and he casted his vote in favor. Okay, so now this has become one more vote in favor. So now this became 7 and this is already 7. So 7 votes in favor, 7 votes against. So now there is equality of votes. Now can he vote as a chairman? Can he vote as a chairman? He can vote as both. Yes, now we can vote as a chairman because in case of equality of votes, chairman will put his vote, right? So now he casted his vote as a chairman in favor. So now in favor it is 8 votes and against it is 7 votes, and due to this majority votes, chairman declared this resolution as passed. Okay, so please examine the given circumstances and explain the validity of this resolution which is declared as passed by the chairman. Any problem with this or resolution passed by the chairman is valid? वो नहीं बोल रहा हूँ मैं. First you tell me the main answer. Resolution passed by the chairman is valid or it is not valid? It is valid or not valid? Not valid. Why? Sorry? No, that is for SR. Ah, yes, correct. See, this resolution passed is not valid. हाँ क्या हुआ बताता हूँ. This is not valid. Understand one thing. See, obviously, chairman, the same person, if he's a chairman also and he's a member also, he can vote as both. Correct. But there is a timing. See, this person can vote as a member also, as a chairman also. But he can vote as a member only when the voting is going on. In the given question, I already told you, he counted the votes as this and this. Means voting process is over. So once the voting process is over, now he cannot vote as a member. Understood? He can vote as a member only when the voting process is going on. Everybody understood? So now he came to vote as a member, he casted his one vote, and therefore this became 7. So this vote is not valid. You understood? So if this vote is not valid, there is no calculation of 7 votes. That means what is the result of voting? 6 and 7 only. So here there is no equality of votes. So if there is no equality of votes, why now he will vote as a chairman? There is no point to vote as a chairman now, because he can vote as a chairman only when the votes are equal. So therefore, this is the final result, 6 and 7. Therefore, resolution is not passed. Understood? So this way they can put technicality in your question. अच्छा क्वेश्चन है ना? Yes. वो तो ऐसे ही होता है ना यार. देखो कैसा होता है, मैं आपको बताता हूँ. देखो, अच्छे स्टूडेंट्स, अच्छे टीचर्स, अच्छे क्लासेस, अच्छे क्वेश्चंस एंड अच्छा रिवीजन सीरीज है ना. सो यू आर वेलकम. चलो देन, मिलते हैं नेक्स्ट टाइम. आगे बढ़ते हैं. टुमारो वी विल रिवाइज शेयर कैपिटल फ्रॉम मॉड्यूल. ओके, चलो देन, बाय बाय. थैंक यू सो मच. सी यू सून.